From Number 5 Chambers, I'm Richard Kimblin and this is the Planning Podcast. In this episode, we're joined by Harj Narulla, who is going to help listeners get to grips with a tricky set of issues. What is an EIA project? In what way do climate change effects have to be taken into account in an ES, and what can lawfully be left out of account? The case of Finch helps us with these questions, and we're going to be guided through that judgment, which was decided 2-1. So even in the Court of Appeal, there was dissent about the outcome. Let's get to it. Hi, Harj, how are you this afternoon?
Very good, Richard. How are you?
Yeah, really good. Thank you for joining us again. You were with us a little while ago in November when we did episode 28. Everybody will remember it instantly. Everybody will remember it absolutely front of their mind when we talked about climate litigation, and we had a chat about a case called Vorlich, which was ultimately decided in Scotland. And you were brilliant. So I've got you back again.
Thanks, Richard. Yeah, it's seared into my memory. So very happy to be back and looking forward to discussing this very exciting and somewhat similar case.
It is somewhat similar. So we're going to switch from Vorlich to Finch. Finch is a case which taxed a mineral planning authority, not in respect of sand or gravel or hard rock or anything of that sort. It's in respect of oil extraction. Listeners to the planning podcast might instantly think to themselves, I don't really need to know about things that happen in mineral planning authorities, particularly if it concerns oil. But what we're going to do, I think, Harj, is explain to listeners what the practical implication is for everybody who's doing EIA development. So let's have a crack at practically why this matters to those who are scoping out EIA. And we can perhaps have that as the first part of our podcast. Then we can turn to the nitty gritty. So practical points we can drag out first. This is a case concerning oil extraction in the Weald, and local people very much objected to that. And we did flag up in November that this case was going to the Court of Appeal, and now we've got it. What was the essence of the Finch appeal? Help us with that.
So this was a judicial review of a decision by the Surrey County Council to grant planning permission for the retention and extension of an existing oil well up at the Horse Hill well site near Hawley. And so the main question in this case was essentially whether it was unlawful for the council not to require the environmental impact assessment in the case for the project to include an assessment of the impacts of greenhouse gas emissions resulting from the use of the crude oil, which would be extracted from the well as fuel, so the burning of that oil.
So this is sort of the downstream effects were at issue. Should the ES have looked at those downstream effects? So it's really a case about scoping.
Yeah.
What should the scope of the ES be? And we had a little look at that, as I alluded to earlier, in November, because the same sort of issue came up in a case which was ultimately decided in Scotland. Mm-hmm. And listeners can go back to episode 28 on that. The claim failed in the High Court, and off it went to the Court of Appeal. The Court of Appeal has now looked at it and dismissed that appeal, but the Court of Appeal judges not agreeing on all of the issues with what went on before. Do you want to just sketch out for us what happened in the High Court and where we ended up?
So in the High Court, they rejected the appeal, and there are a number of points on which that was done, which I think we'll come to later. But the relevant question here revolves essentially around the requirements of the EIA directive, which is incorporated domestically through the EIA regulations. And those instruments require that public and private projects, which are likely to have significant effects on the environment, will only be granted consent where there's an assessment of those environmental effects. And the regulations for this particular project set out that you look at projects that extract petroleum and natural gas, they need to have an EIA. So the second defendant here, which is Horse Hill Developments Limited, had applied to retain and expand their well sites. They wanted to dig 4 new wells, which would operate for about 25 years. And that would be obviously well into the 2040s and would extract around 3.3 million tons of crude oil in that period. So just in terms of the EIA process itself, the planning authority prepared a scoping opinion which looked at some of these likely significant environmental effects. And they recommended that the EIA should include an assessment of the emissions of the oil and gas produced at the site, as those were significant indirect effects. That's what they initially said in the scoping opinion. But then the developers, Horsfield Developments, didn't follow that recommendation, and they produced an environmental statement which was focused only on the emissions flowing from the site's construction, production, decommissioning, and restoration, so the more direct emissions. The council then in turn accepted that environmental statement and granted planning permission for that, and that was what was challenged in the Court of Appeal. So we have a question here essentially around what was the appropriate content for that environmental statement and whether or not it could be reviewed as unlawful by the appellant.
So, Harj, there's this question whether or not to look at these indirect effects. Is it a legal test? If it is a legal test, what is it? Or what did the court tell us? Or what did the courts debate in terms of how you go about deciding whether or not those indirect effects, those downstream effects, fall within the scope of what's required in an ES?
So in the High Court, Mr. Justice Holgate adopted a legal test and he used specific wording. He said that the test is whether an effect on the environment is an effect on the development for which planning permission is sought. And this is obviously mirroring the language both in the regulations and in the EU directive. And this was obviously a point of appeal and ultimately a formulation that the Court of Appeal rejected, which I think we might come on to a bit later. There was different views that were adopted by the 3 different justices in the Court of Appeal about this test. But essentially, this is one of the key issues in dispute in the case.
Let's have a stand back from that just a little. Help those who have to deal day to day with the question of what goes into the scope of an ES. In practical terms, what do you say the upshot is of this case?
I think, in effect, there's not a formal requirement on planning authorities to include these indirect or downstream emissions. The position of the Court of Appeal ultimately was that it's a matter for the discretion of the planning authority whether or not they assess these particular factors. And therefore, it's not a formal legal requirement. That was the position of, I think, all 3 of the judges. So they were agreed, I think, on that point in particular.
Okay, that's helpful. That will help people. But then the judges went off and discussed whether or not the ultimate use of the oil was the project. And so if I put some diesel or some petrol into a vehicle, am I part of the project?
Yeah, I think there are a number of questions here, and it's maybe worth tracking the different arguments that were put in the case. So the appellants were arguing that the definition of the project or the development was too narrow. They proposed different formulations for how you should think about the legal test or any analysis of the definition of the project. The appellants argued for a reasonable foreseeability sort of standard. The interveners spoke about remoteness in time or effect, or in time or location of the effects. And so there were different approaches essentially to try and unpick this question of what the project is. I think one of the kind of key other points that was contested was around the idea of the purpose of the project. So you have here obviously a well that's extracting crude oil, and the argument from the appellants was that you need to take into account the purpose, the commercial purpose of that activity, which is geared towards the refinement and ultimately burning of that crude oil when you're thinking about the definition of that project. And they argued that trying to limit the scope of the valuation simply to the development, the project that's being done itself on the site, the mining, the digging activities, the construction of the infrastructure, the land use component, confining it just to that point is too narrow a definition, and that we need to look at these later and subsequent steps when we're thinking about the definition of a development or project.
Now, the court came up with or had a look at additional formulations such as attributable to or but for. How did they get on?
They're essentially rejected in formal terms, but I think this is one of the interesting points of the decision, the leading decision by the senior president of the tribunal, which is that having rejected these causation-related standards, he nonetheless then adopts a different standard, which some could say actually still brings in causation. And this is essentially the question of you need to look at the link between the project and its putative effects, the connection between those things. And we can see that potentially as just a restatement of this causal question, which the appellants were trying to resolve by saying we need to adopt a reasonable foreseeability standard to think about what that connection is between the project and its putative effects. So to answer your question, it was rejected outright, those submissions, but maybe there was a kind of reopening of that logic, at least in the standard that was ultimately adopted by the court.
Okay. Well, that is an interesting outcome. Let me look at it from a slightly different perspective. Suppose an ES does look at those greenhouse gas emissions, or you've got a situation where you actually conclude that those greenhouse gas emissions are indirect effects. Is it unlawful to look at them in an ES?
The court said that it's not unlawful. That was the position and the finding of the High Court. They rejected that approach. They said that that's something that could be taken into account by the planning authority, but it was ultimately a matter for their discretion and would be decided dependent on the particular facts of the case. Essentially, it's kind of putting that decision away from the courts and resting it with the decision makers.
Leaving it with the decision makers. Matter that's familiar to many of us who follow the planning court and their subsequent excursions to the Court of Appeal. Readers of the case will come across something called Scope 3 emissions. Let's just pick up what that is. What is a Scope 3 emission?
There are three categories of emissions that are normally used for greenhouse gases, and they're called scopes. So the Scope 1 emissions cover direct emissions from things that might be owned or controlled by businesses. So in this case, that would mean, for example, the emissions coming from the vehicles driving around the well site. Scope 2 emissions covers indirect emissions from the generation of purchased electricity, steam, heating, and cooling. So in this case, that could mean things like the emissions coming from electricity that would keep the lights on in buildings on the well sites. But Scope 3 emissions, the really contentious one, is often the largest category of emissions for any organization. And that covers all other indirect emissions in an organization's value chain. So what that means is emissions that come from assets which may not be controlled or owned by an organization, but which their activities might affect. So again, some examples here could be the transport of goods to and from the well site, the commuting of employees who go to the site to work. But importantly, the kind of key one for this case is the burning of any crude oil products which would be produced as a result of the site. And remember, we're talking about 3.3 million barrels of crude oil, which is a lot of emissions over time.
And the upshot of the judgment is that those Scope 3 emissions remain outside of the scope of assessment. That's where it gets to.
Exactly. And there are obviously a range of views as to the appropriateness of this. I think one of the interesting things about Scope 3 emissions is that they include the Scope 1 and 2 emissions of other entities and organizations. And one of the key ideas in this case is that planning permission and environmental impact assessment should happen for essentially discrete projects. And rather than trying to take into account all of the different emissions that might arise down the chain of causation, A more appropriate approach is for EIAs to be carried out for subsequent and distinct developments. For example, a refinery that is refining the crude oil which is extracted from the well site. So you see there an attempt to interact with how we can meaningfully grapple with Scope 3 emissions and the fact that it overlaps into, as I said, the Scope 1 and Scope 2 emissions of different organisations.
I'll contribute this. I spent on and off a year in an inquiry in mid Wales into some then Section 36 consents for some substantial wind farms. And very early on in that year spent in Welshpool, there was an argument. And the argument was this: the developers want to erect a number of very substantial wind farms. They're useless without a grid connection. It's necessary, therefore, to fully assess the landscape impact of the grid connection, pylons, alongside the landscape impact associated with the wind farms. Answer: different projects. The wind farms, one project to be assessed by reference to that project. As and when the grid connection comes forward for consent, that will be assessed. And in that way, EIA undertakes the necessary assessment of both the project itself and also the cumulative impacts. And that's sufficient to pick it all up. And that was the decision in that case. And the curiosity and the contrast, of course, is that the wind farms were green development, but nevertheless opposed. And the point that was taken against them, the point that was sought to be made by opponents of the scheme, was that the whole thing should be collapsed together with a view to increasing the impact to be weighed against the proposals. Here, it's flipped. The oil exploration and the oil exploitation is not a green proposal. The downstream effects sought to be included in the assessment in a different way. So it's not a new point, and it seems to come up in energy developments in a variety of ways. But I thought I'd throw that one in, just to get in the fact that I'd spent a year in Welshpool.
Very impressed.
Anyway, Harj.
It's a fascinating one, Richard. I might pick you up on that if that's all right.
Yeah, go for it.
I think there's an interesting point here, which is around the difference between the project you just described and this case is around not knowing where the oil and its products will ultimately go. The example you just raised was one where EIA could viably be used to capture the entirety of those set of considerations. Here, as was found both in the High Court and in the Court of Appeal, they don't know where the oil that's extracted will ultimately end up. All they do know is that it's inevitable, and this was a finding of the court, which was affirmed, it's inevitable that it will be burned. So there's a question about whether or not EIAs can be used at each step along that causal pathway, from digging it out of the ground, refining it, transporting it, combustion, whether or not the emissions can be captured by that process. And I think that there's a kind of potential issue here of salami slicing, where if you try and only assess each of the discrete points, you have something that's less than the sum of its parts. You don't actually capture the emissions profile of the burnt oil. And that's the argument that's being made by the appellants here, that the only appropriate time to try and take account of all of these emissions, the Scope 3 emissions, is at the beginning of that causal chain when you're taking it out of the ground.
And in my Welsh example, there were projects to be assessed in due course. In this example, the burning of the oil, wherever it's burnt for whatever purpose, is in many respects unlikely to be the subject of any planning application, which would be subject to EIA. That's clear as a difference, isn't it? And that's what you're highlighting. So thank you for that. And indeed, it seems that these alternative views received some support in the Court of Appeal, because there was a dissenting judgment by one of the three Court of Appeal judges. So let's cover that off. What was the contrary view?
So Mr. Justice Moylan essentially disagreed as to the lawfulness of the decision taken by the council. And this turned ultimately on the approach to the EIA regime. He adopted a broad and purposive interpretation of that regime, which essentially approached this key question of what a project is in a more expansive way. He looked at the history of amendments to the EIA directive in 2014 to include climate change. There's an explicit focus on capturing greenhouse gas emissions. And he found that it was more appropriate for the definition of project to be interpreted expansively to consider the Scope 3 emissions.
Okay, so the appellants were not entirely unsuccessful in their outing to the Court of Appeal. They persuaded one judge, particularly by reference to the purpose of the directive. The directive is there to be looked at broadly, and if you do that, you get a different outcome to that alighted upon in the High Court. So maybe it's a case that will go further, so perhaps we should say little more about it and wait to see if I can get you on a third podcast if the case does go further. What do you think about that, Harj?
Can't wait. It might be a little while until that happens, but I'd love to come back, Richard. I always like speaking to you.
You're very generous. Thank you very much indeed, Harj, and have a great rest of your afternoon and indeed weekend.
Thank you. You too.
That was the Planning Podcast on the first of two climate change cases. We hope you liked it, and we'll hope you'll turn to the next one, where we look at what's happening in respect of the High Court. A case there had two judges sitting, and they disagreed. More dissent on climate change topics. Till the next time, goodbye.